Good afternoon, everyone. Hey, what a difference a week makes. If we would have had homecoming last week, for those of you from out of town, we had, at least in Denver, we had 6 inches of snow. So we're very pleased that we don't have that weather today. My name is Georgette Vigil. I am the Senior Director for Alumni Engagement and Outreach and Donor Relations at your alma mater. Yay. How many alumni in the room? We have a ton of alumni. How many from out of town? Thank you for making the trek from out of town. Okay, we'll go. Anyone from the 60s? 70s, 80s, a lot from the 80s, 90s, 2000s, 2010s. Okay, so you have an idea of your audience today. So this tradition dumbfounds me every year because to think that during homecoming that we have these committed lawyers that will take time to do a CLE credit is outstanding to me. And so we're very pleased that you're here. We put together an excellent panel of alumni who are going to chat with you today. I'm going to turn it over to Amy.
Georgette's, whoa. I echo Georgette's thanks. Thank you to all of you for being here. We're excited to see you. We're excited to see faces in the room. The excitement in Boulder is high, so it was great driving in today and seeing all of the people and all of the fun. I've done this presentation a few times, and I did it first probably 8 years ago, and I'll tell you the crowd then was nothing like the crowd now, so it's great to see. I'm Amy Devan, and I'll be the moderator today. I'm joined by Sonny and John Fero. They're going to introduce themselves in just a moment. I am a lawyer. I am one of the 2000s lawyers. I was, until very recently, the executive director for Wheeler Trigg O'Donnell after being the firm's ethics and compliance counsel for several years, and prior to that, working with the Colorado Supreme Court's Office of Attorney Regulation Counsel. I've enjoyed a nice summer break. My husband, though, is gently reminding me that Thanksgiving is no Labor Day and summer is behind us, and it's time to start thinking about what's next. So getting back to my love of ethics and risk management, and that starts here today. So what we want to do today is really add to the discussion around emerging technologies, alternative intelligence, but others as well. There's been so many CLEs, so many great CLEs about AI and emerging technologies and the interplay with legal ethics. What we want to bring to that discussion today is the unique perspective of in-house general counsel and outside counsel representing companies, and what the tension might be around the use of emerging technologies in terms of what general counsel might be looking for to protect the companies, and which is their client, and what outside counsel might be looking for in terms of freedom to do the work that they've been hired to do. So Sonny and John bring those unique perspectives, and I'll just chime in whenever I have thoughts. So Sonny, you want to start with an introduction?
Sure. Thank you, Andy, for inviting me to come here today. It's always great to come back to Boulder. I live in Arizona.
Can you put your mic on? I don't know if you have to.
It is.
It is on?
How's it going? So my name is the company that I was general counsel for is called On Semiconductor. And one of our taglines was, we turn on your technology because we made all the chips in the power management area. So I'm going to do a switch out.
John, why don't you go while they switch Sonny's mic?
Sure. I'm John Fero, class of '04, and let's see, so I spent the last 7 years teaching ethics here as an adjunct, and my day job, my regular job, is I'm a partner with a small firm in Denver, Simple Farrington and Wrong Case. We specialize in civil litigation, represent lots of companies and nonprofits and businesses as well. Hello.
I think he's got it fixed.
Okay. Before that, I worked for the Attorney General's office for about 12 years.
Okay, with that, can you hear me better?
Perfect.
All right, great. So I'm a graduate of this law school from 1985. So I'm coming up on the 40th years in a couple of years. And back then, we were in the Fleming Law Building. And so anyway, I was saying it's great to be back here. I love this school, and I love Boulder. And so I was the founding general counsel at a multi-billion-dollar, multinational semiconductor company called On Semiconductor, headquartered in Phoenix, Arizona. It was a spin-out from Motorola. I had been in-house at Motorola prior to the time of the spin-out, and I had actually left the Motorola Law Department and had joined the business group doing mergers and acquisitions in emerging market countries. And then when they decided to do the spin-out, I was the only person who was in that business that was a lawyer. So they asked me to be the general counsel for the new company. And I was a little reluctant at first because I was having a lot of fun doing mergers and acquisitions. But I said, yeah, I'm game. And I ended up having a long run at it, over 22 years, and just retired last year. Dealt with incredible amounts of different issues from all around the world. And we'll get into some of that maybe in our examples later. But thank you all for being here as well.
And one of the things that we really want to approach today's discussion, you know, we are lawyers. We are not tech experts, though I tend to flatter myself and think I could do tech support if I had to. But I think the tech support at the firm would disagree. But at any rate, I think it's key to remember, you know, with every generation, there's something new. I had brunch yesterday with the director of IT for WTO, and I was like, you know, it was back in the day when people were typing on Selectric typewriters, right? And then it was like, do we trust these word processors to convert? And then do we trust computers? And do we trust going from WordPerfect to Word, right? There's all these changes. This change with emerging technologies now is obviously a sea change. It's something that none of us have seen before, probably none of us could conceive of until recently, but it's still just one more change, right? And so I think there's this real hand-wringing of, do we need new rules? Do we need new thoughts around this? And I think it's really just continuing to do what lawyers have always done. Take the rules that we have and apply them to this new technology and figure out how we can use it ethically in our practice. So to kick us off, John's got a little demo so that we all can be on the same page about what we're talking about today.
Well, it's already up here on the screen. So this is Chat GPT. This is a Microsoft generative AI product. Anybody can get it for free. You just go to the website here, OpenAI. You have to give them your email address so they can spam you to the end of time, and then it's free. If you want to upgrade, you got to pay for that, but the free version gives you current information up to about 2021. Has anybody in here used this before? Okay. I mean, that's what, roughly a third?
Yeah,
maybe
I'm
a little,
surprised.
yeah, maybe 40% tops. Okay. Have you used it just for legal work? Any of you that had your hands up? Nobody? There's somebody. Oh, okay.
Here.
Thanks. Yeah, to ask legal questions or use it for generating work product?
Simple drafting, amendments without putting in confidential data, but like draft me a 1-year extension to this and then I'll further draft it. But especially GPT-4 is quite good at that stuff, simple stuff like that.
Okay. So the answer for those online was like that you can use it to generate kind of a starting point for, sounds like fairly simple work product. An amendment to an agreement is what I sounded like you were saying. Okay. Well, it's a powerful tool, and I typed this in right before I got here because I forgot my notes, and we're supposed to do this program today. And it's amazing, if you've never used it, how quickly this is. So if we had just typed it in, look how quickly this is. And it just gives us a full outline for our presentation today, and you know, then we're done. So
You're just going to hand that out.
Any questions?
right. But you can certainly ask it more complicated, I shouldn't say complicated. You can ask it anything you want to ask it. And part of what we really want to discuss today is what should you do with it?
Very good.
And of course, we all know there's, you know, the show of hands of who's used it. Those of us, including me, I used it to test draft policies. As executive director at the law firm, we were contemplating changing some of our employment policies. And that's one of my least favorite things to have to sit down and try to figure out. So I used ChatGPT and I said, give me the beginnings of a family law or a family leave policy that comply with Colorado rules in 2023. And it spit out a product. And then I refined it a little more. And it gave us a good starting point. There's obviously, refining you want to do. But for those of you who didn't raise your hands, I would suspect you've used it even without knowing you were using it, because you may not have gone to this website, you may not have used it as a tool, but there are so many AI-powered features online now. LexisNexis, Westlaw, they're all building AI into their search engines and into their features. I had a pop-up on LinkedIn the other day that said, hey, do you want to use our new AI tool to help rewrite your profile? And I said, sure. And it actually made it better. I had to do some refining, but it was almost like Grammarly. It took out the extra words. It made things a little more streamlined and a little tighter. So even those of you who didn't raise your hand, you've probably used it even without intending to use it, just given your daily life. And so with that in mind, what we want to talk about is, how do we put framework around that as lawyers? There was a great CLE just a couple weeks ago here in this room, the Silicon Flatirons, along with Melanie Kay, John's cohort, teaching ethics here at the law school. And they talked a lot about ChatGPT and the advantages that it can bring to the legal practice, which we're going to talk about a bit later. So Sonny, let's talk about an introduction from corporate counsel perspective. How would you, as in-house counsel, approach the conversation with outside counsel about the use of these emerging technologies? Would you want them to use these? If they did use them, would you want to know about it in advance? Would you think about forbidding that use? And what would drive your decision-making on that front from a business perspective?
Sure. So you start with, this is an absolute must-have conversation for general counsel or any lawyers working in-house with their outside counsel. And I see I've got a colleague here who's a former general counsel. So these conversations that you have with your outside counsel, you have an ongoing conversation about the work and what they're doing, but this is a new frontier. And so in the law department I ran, we were very strict about not allowing firms to do work for us unless they had an engagement letter. And it was a corporate policy. So I would want this to be addressed in the engagement letter. And so what that means is now you have to go through all your law firm providers and go pull out the engagement letter and then have this conversation about what is acceptable, what's not acceptable with the use of generative AI tools when they're performing legal work for your company, which is your mutual client. And so, how do you start that? Well, one, it's fairly scary because, as we'll talk about a little bit later, these AI tools, they can be prone to hallucinations. So everybody's probably read the Matta case out of New York, where the lawyer used it to prepare a brief, and ChatGPT manufactured case law to support the arguments that were being made. The guy got in a lot of trouble over it. And it was funny, because when he was defending himself, one of the things he said was, listen, I asked ChatGPT whether these cases were real, and it said they were. And he said, so I did my diligence. That did not go over well with the judge. And my point about bringing that up is that you got to have these conversations with your outside counsel, because if they're using it and you don't know about it, you could be in for some big surprises, and the name of your company could get dragged in. You could be part of the controversy. And that's something that's very important in the relationship between inside and outside counsel. It's not so much, it is a lot about the quality of the work and how it's performed, but it's also, what the law firms are doing that could impact other areas of risk for the company, particularly reputational risk. So it's a must-have conversation. So, how do you go about that? So the first thing I would do is, benchmark. What are other companies doing about this dilemma of working with law firms and analyzing whether they should or should not be able to use generative AI in the performance of their legal work? You'll probably find that there are some companies that are way ahead of others in this, particularly in the high-tech area. So I would want to benchmark what other companies are doing. And speaking of benchmarking, there was a recent Thomson Reuters survey that was conducted earlier this year. And the data is probably already pretty aged because this stuff changes fast. But they asked corporate legal professionals if they were using these sorts of tools in their organizations. And the answer at the time of the survey was about 1 in 10 professionals were either using it or planning to use it as a regular matter of course in the legal department operations. And then they asked, law firms, what is the rate of utilization? It was actually less than the in-house lawyers. And they were asking, are you using it for legal work? So it wasn't just, playing around with it. And then what was very interesting about this survey was they asked the in-house lawyers, do you think outside law firms should be using this? And 25% of them said, absolutely no.
Oh.
That I would not want them doing this. I think that number is probably different now. But then there was another question that got, a follow-up question that got asked of the in-house lawyers. Do you know, as you sit here today, whether your law firms are using ChatGPT or any tools like that? 80% of them said, I have no idea. So that's why I go back to, this is a must-have conversation. You cannot just rest on this. If you're working in-house, I would say you better get on it and you better get a policy in your company. If you don't have one, you're already behind the 8 ball. For me personally, I'm more of a cautious, technocrat optimist than a technology doomsayer. So I'm okay with using these types of tools. I don't have a categorical no, but I would want to, create the guardrails, create the understanding of when it can be used, and when, that there's sort of pre-approval to use it. When do you need to bring up the discussion again? Say, hey, we're thinking about it for this other project. What do you think? And then, areas where, I would have some off limits. We're going to talk about those a little bit later in this presentation. So you also asked, what would drive my decision-making on that? So, obviously you want to do a pretty rigorous analysis of the pros and cons and the risks. And that gets into, a lot of detail of what the capabilities of the tools are. And then you would want to map that to, what your company's risk tolerance and profile is all about, the type of industry you're in and so forth. But there's another aspect that I would want to have a conversation with outside counsel about, which is this, what I say is now an avalanche that's starting to happen with regulatory oversight and rulemaking in this area of AI. So probably some of you, many of you may be familiar, the European Union has been contemplating this for a couple of years now, and they are pretty close to passing what they call an AI law. They were expecting it would be completed this year, but it looks like it's now going to be pushed into early next year. And it's a very comprehensive framework, typical EU approach to things. And it takes a risk-based approach, but it divides up the, come a little higher, it'll stay on, there we go. It'll basically, depending on what the level of risk is considered to be for a particular use of AI, then the amount of regulatory requirement, will increase for higher risk, it'll be less for lower risk, because it makes sense. And also in typical EU fashion, when it gets passed, it will apply to anybody who is either putting AI tools into the market or who is utilizing them. And that won't matter whether those providers are established in the EU or not. If it touches the EU in any form or fashion, it gets caught under the regulation. And so then, as I started looking at that, then I found, boy, there's a lot of other areas where this is being looked at. So in January 2023, NIST issued, it was voluntary, but an AI risk management framework. And then just this past Monday, probably everybody read the news, the Biden administration issued a very comprehensive executive order for basically executive regulation of use of AI in the United States. It actually directs a lot of the agencies of the federal government to start doing research and publishing new rules in this area. So there's a lot of detail that still, will come there. On that same day, the G7 countries agreed to a code of conduct for AI companies. And then just in the last couple of days, the UK had a forum that was hosted by the Prime Minister to focus on risks posed by AI and large language models like ChatGPT, and these other ones are called large language models because they incorporate so much data. And anyway, in that forum, nearly 30 countries signed a declaration to cooperate on ensuring responsible development and oversight, and this included the United States and China. So I would want to have a discussion with my outside counsel about all these types of risks and factors, and I would want to particularly talk to them about what do you see coming with respect to the regulatory overlay, because we don't want to be caught, in a trap because we weren't thinking about that ahead of time.
And I think that really comes to bear when it's an international corporation,
Yes.
where you're juggling not only US law, but international law, and how do those things come together because your risk profile is so much greater. And as inside counsel or general counsel, you're not only thinking as a lawyer, you're thinking from the perspective of the business, and you have both of those hats on. So John, with that framework, as outside counsel representing corporations, insurance companies, individuals, how do you feel about that? And how would you react as a lawyer wanting to preserve your independence to make your legal decisions if corporate counsel came to you with these issues?
Well, it's going to happen, right? Sonny just told us that you need to do it. So if you're outside counsel, you better get ready. And I'm sitting here listening as Sonny was talking. I'm thinking, I hate those conversations. Am I the only defense lawyer, civil defense lawyer here? We're not the only two, are we? Amy, you were in a civil firm.
Yeah.
Used to be, retired now? Yeah. Well, I deal with a lot of insurance defense too. And there's not any insurance adjusters here, are there? Good. Okay. No, I'm only kidding. But it's not uncommon for organizational clients or insurance companies to try to micromanage the representation. From your perspective, it's not micromanaging, right? From mine, it kind of feels that way sometimes. And I know a lot of it is driven to control cost or prevent reputational harm, and those are all perfectly valid. And, frankly, the lawyer from outside who's doing the representation should be thinking about those things too. But, one of the ones that we get into it all the time. It's a simple one, and I think it's very similar to what we're dealing with now, is can I charge an insurance company for Westlaw time, right? They say, you have to call us. This is in our new guidelines. You have to call us before you can spend 1 minute of a Westlaw charge. And typically we say things like, we can't agree to that. You know, because our rate is negotiated to where we separately charge research. It's not high enough to count that as overhead. And by the way, we're never going to agree to represent you if we can't do competent representation. And if we think we need to do legal research, we're going to do it. And so how is AI a different tool? I was thinking about the different tiers of classes and decades we have here, and I'm wondering, we have practitioners here, right? You were around using the digest, right, and the books. And then suddenly electronic legal research comes in. Was that a sea change in the profession? I see some head nods. Yeah. So, you know, feels very similar, and yet also we can't predict how much it's going to change the profession. But you know, you have to think about kind of the nuts and bolts of the ethical issues. And I'm glad that Sonny is thinking, you know, from the inside perspective about all these granular organizational, institutional risk management perspectives, because I want to focus on, you know, the end of the representation that we've talked about, and I want to focus on the means. How am I going to get you to what you want to get to, right? What's the pathway that I'm going to try to do? How am I going to get there? I'm plotting a course, and what are the tools I'm going to use? And of course, if generative AI is something that I can use, then I need to consider that, but it implicates several professional concerns. And as from my perspective in that conversation, I think ultimately, lawyers make the worst clients, right? But I would like it to be with someone like a lawyer, like Sonny, a GC who's done the work and is experienced, because they will appreciate the perspective that I have to bring to it as outside counsel. And just a few quick points about that. I mean, you know, lawyers we're supposed to be an advisor. We're under Rule 2.1, and that means, and you said it, Amy, independence. It says the lawyer shall exercise independent professional judgment. What is AI doing? Is it just gathering information for you, or is it making judgments, right? Because it has to be your judgment. It has to be yours. And it always, you can't allow whatever this technology is to take that over. And that's what makes, I think, this very different from, say, Westlaw versus the books, right? Because, you know, Westlaw, at least as we've used it over the last whatever, it's not been making a lot of judgments about final conclusions and strategy and whatnot. The other, just in terms of a couple other points, you know, what about the scope of authority? I mean, is it even in the realm? Is it even a fair thing for, you know, who gets to make this decision, I guess is the way I'd frame it, about whether you can or can't use generative AI. And I think it's a really tough question. The rules really weren't written to contemplate this type of technology. And, you know, the rules cast very broad strokes. So what kind of guidelines did they give us? I mean, and I laid out one of them for you, 1.2, scope of authority. I mean, typically the client decides where they're trying to go and what the goal is, and the lawyer figures out the best way to get there. But one of the comments says, clients normally defer to the special knowledge and skill of their lawyer, particularly regarding technical, legal, and tactical matters. Conversely, lawyers usually defer to their clients regarding questions as to the expense to be incurred. And, you know, generative AI, I think, has a significant impact on the expense to be incurred. The idea, I think, is that it's going to save expenses. So, I mean, do you think that, I'll just go back to our audience member here who said use it for some work product help. You think it's a time saver, a money saver?
It's definitely a time saver for me, and yeah, I would have to hire more external resources. I'm the general counsel of a software company, and I would have to hire more external resources in some initial research on my own end, just to kind of get a lay of the land like you would do a Google search, just to refresh your memory.
Yeah.
All those things.
Yeah, I agree. Just a little bit I've used it, it can really help
help you figure out exactly where you need to go in a problem. But you can't be like the practitioner who just relied on what it said and then filed a brief and said, hey, judge, here's what it told me, and it said it was true. But I think this issue really kind of goes also to the old debate about, and I'll use 2023 parlance here. Are you talking about representation that's the quality of a Nissan Leaf or a Lucid Air, right? What are we paying for? What are we providing? I mean, there's nothing incompetent about a Nissan Leaf. And, maybe the Lucid Air maybe that's overbilling. Maybe that's more than the case takes. So there's so much professional judgment that you have to use in any given situation. But I totally agree with what Sonny said about it's time to, have those conversations. And yeah, I think we need to have them. I don't look forward to having them, but I think they're very important. And the only other comment I'll make about what you said is all the stuff that Sonny was recounting about what's been happening in the world. Well, the ABA just got around to forming a task force on this in August, I believe. So I think the profession, and just even looking at the show of hands in here today, I think the profession is behind the curve on this, right? I mean, this product dates from when? When did it first go live? We were talking about this,
November 2022, I think the current version. Yeah.
I mean, so, for those of you that are like me that are in a firm, if you're online too, if you think that no one in your firm is using it, you're probably wrong.
And that really leads to, I attended a meeting with a malpractice, led by a malpractice insurer. And that was the question in the room to in-house counsel for law firms, as well as ethics counsel for law firms, as well as people who sat in my seat. And the question was, what are you doing? And at that point, this was, I think, in May, a lot of the questions were around how much of a guardrail to put, because what you don't want to do is drive people to using it in the shadows, right? Like one law firm general counsel said, I don't want to make a policy that says associates can't access this technology from their work computer, because then what they're going to do is they're going to access it from their home computer, where I have even less control over what they're doing and less insight into the documents that they may be sharing. And I don't want to drive them to that. So I'm going to start from the premise that this is a tool they're going to want to use, and I'm going to try to figure out how to harness that, put guardrails around it, give them cautions around the use. Think of things like sharing non-confidential information, worry about the server's location if you're uploading documents. Is that a server that's stored in, a foreign country that has less data controls, or is that a server that's onshore in the United States? So it's really more about educating the users internally versus a total ban. Other firms have a total ban, and it's really, as we all try to figure out what our comfort zone is. And again, this is just one more tool in an arsenal of tools. This is the flashy one. This is the one of the moment. It's the one, I love this podcast. I'll do a unpaid plug for the podcast Hard Fork. I don't know if any of you have listened to that, but it's two tech guys. One, the columnist Kevin Roose from the New York Times, who had the infamous chat with the Microsoft chatbot that was like professing love for him and trying to break up his marriage. If you haven't seen it, it's actually really funny. And it was kind of scary. But he and another podcaster do this podcast Hard Fork. And it was like from November until March, every weekly episode was just AI, because it was like stuff was coming so fast and fierce. And it's hard to keep up with it. I just heard another great podcast from the Wall Street Journal does a podcast called The Journal. And it was a conversation with OpenAI's Sam Altman and their head of tech support, or tech, basically, who I forget her name, but I was just excited that she was female. And I thought that was great to see, a female head of tech in a cutting edge company like this. But at any rate, they were talking about the next generation, right? And this generation, the next generation, they're calling it, I've heard it as alternate generational intelligence or alternate generation intelligence, but it's AGI instead of GAI. And Sam Altman's point was like, this technology, for all of us that are worried this is going to replace us, and there are plenty of associates in law firms who are worried that, like, how am I going to make my billable hours with this technology out there now because it can do what I do? But it doesn't yet, right? Like, since Sam Altman said that, it doesn't replace the human experience. It doesn't replace your knowledge. It doesn't replace your institutional history and the other things you carry around in your head, because as sentient as this feels, it's not sentient. It's not actually thinking. The hallucinations is a funny term for it doing these weird things that no one knows why it does, but it's not thinking yet. But the next generation will, and that's where things get scary if you're concerned about this. And so that's where people are looking for it. So with all that in mind, John, as a practicing lawyer and also wearing your hat as an adjunct ethics professor here at the law school, do you think that lawyers, I told you I had brunch yesterday with my IT friend, and of course he's very bullish. I'm pretty bullish on it, but he's very bullish on it. And he's like, we can't put on blinders. And he's at the table like going like this. And some lawyers want to. Some lawyers want to say, put on my blinders, I'm going to ignore this, and I'm just going to do it the old-fashioned way, which is not nearly old-fashioned compared to, what some of our framework is. But do you think that lawyers can just put on their blinders, or do you think lawyers are ethically obligated to use these tools or other emerging technologies? I mean, we're talking a lot about AI, and it's the one that's the elephant in the room, but there are other technologies out there too. To meet competency requirements, are lawyers required to use these things, or can lawyers put on their blinders and elect not to participate? And if they do decide to use them, what does that competency look like so that we don't become the New York lawyer submitting the brief to the judge?
Well, great questions. The key to me, and I'll start by not answering it, but the key to me is, what is generative AI doing? And I alluded to this when I spoke before, but it's, the practice of law involves a lot of very distinct skill sets and a lot of different tasks. But, generally I think of it as like, you got to go out and, the kind of work I do at least, you got to go gather the facts, right? What is my, I've got a bundle and I'm going to put a bunch of sticks in there, and what are they? I got to know what happened. And then I need to gather the law once I figure out what the legal issues are, but I got to figure out what are the rules that are governing this issue, right? Some of them are going to be really crystal clear, and a lot of them probably aren't. And then I got into more of the analytical stage, right? And then you're thinking, okay, they're helping me decide the scope of the law that I need to work with, which facts matter, which ones don't, right? I mean, we all know this stuff. And then finally I get to the actual application, which does everybody remember what they used to call it in law school, by the way? When I was there, it was IRAC, and then they called it CREAC, and I don't even know what they call it now because I don't teach legal writing. But you know what I'm saying? I mean, this methodical, analytical approach to practicing law. I mean, is generative AI doing all of those things? Because I think you have to look at what task you're asking it to perform, or that it is able to perform or does perform, because the ethical answer is a little bit different for each one of these. And we know that each one of these different tasks can be the make or break moment of the representation. I mean, you can lose a case because you didn't gather all the right facts, or you screwed up on the law, or you just didn't make a persuasive application argument, right? You can lose. And at that one little step, all this other great work went for naught. But look, I think we all know the rules, right? Competence and diligence, just at the building blocks here, is pretty basic stuff. 1.1 says, it's not going to help a lot for your question. It just says, competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Well, that didn't tell me anything. I mean, it just tells me that it's whatever is objectively reasonable, right? The old Poindexter reasonable person tort standard. I guess we can deal with that. Except here we're talking about lawyers, and we all disagree, right? Comment 1 says, determining whether a lawyer employs requisite knowledge and skill. They give you a bunch of factors. Complexity. How specialized is it? How experienced is the lawyer? What's the training and experience? See, none of this is really giving us a lot to go on, right? Because these rules were written so broadly. Comment 2, some important legal skills such as analysis of precedent, evaluation of evidence, drafting work product, those are required in all problems. Perhaps the most fundamental skill is determining what kind of problems the situation involves, and that transcends any particular specialized knowledge. Comment 5, competent handling of a matter means you need to analyze the facts and legal elements and use the methods and procedures meeting standards of competent practitioners. See, that suggests that the standard evolves over time, right? What is the standard of competent practitioners? Is it different in 2023 than 1983? In some levels it is. Now we have this technology. See, I'm getting closer to answering your question. And I think my answer to it is yes, that you are really doing your client a disservice and yourself a disservice professionally if you kind of play ostrich and put your head in the ground on this issue. Ontology is what that's called. I think you have to actually look into this and see what it is, learn how you can use it, how can it serve your client, benefit your client, advance the ends of your representation, how can it be a tool you can use? And if you're just going to ignore it, I think you're really, I can't say, oh, it violates this rule or this comment, but I don't think that it's consistent with the spirit of the rule. And I'll give you one more comment, which is probably as close as we can find here. Comment 8 says that lawyers have to maintain their requisite knowledge and skill by keeping abreast of changes in the law and its practice and changes in communications and other relevant technologies. So that's the best one I can give you, is like right on point. You've got to do it. Now, what's the business perspective, which I think you kind of begged the question on that too, is, I think that's just fascinating. How many firms are really going to embrace this and how many are going to be pulled into it, right, kicking and screaming, right? But, and the other ethical point I'll just raise about it is I think you have to think about diligence. The idea of this we've kind of been touching on is to make your life better, increase your efficiency. And I'm not sure if it actually will create more work. Maybe Gen 2 won't, but I think Gen 1 might, right? We had the example of the practitioner who said, give me a brief. Now I have to check all of that, right? I got to go and look up now, oh, it gave me this stuff. Now I got to make sure it's right, because I can't just say, hey, Chad, is it right? Yeah, this is right. Sign your name to it, John. You can't do that. I mean, that's clearly unethical. It's not competent representation. And when you get called out on it, you're gonna get sanctioned, right? And maybe you'll get a bar prosecution, although that usually doesn't happen. More likely, it's malpractice. So, and I think business-wise, many firms, particularly if you're on civil defense, right, we are risk averse by nature. So we're going to be concerned about malpractice. And I think there's just, at some point, are we going to get an ethical opinion from the ABA that says, gives us some guidance on this? That's going to pull more people from the profession into it.
And I was thinking about that as you were talking, and I've thought about that as we were preparing, because I'm always sitting in the seat, as the two of you are, of ethics, risk management, compliance, and thinking about how to mitigate the risk for my firm or my company or whatever it is. And all I could think when I read that about the lawyer that did the brief is, now the brief's going to get tossed and his client's defense is going to be hampered. And Sonny, as general counsel for a corporation, I'm sure that would be your first thought. Like, okay, outside counsel, you did this thing, and now what does that mean for me? What does that mean for my company? And what does that mean for our business? So what are your follow-up thoughts based on what John said about whether or not lawyers can just ignore this exists, pretend it doesn't, whether they need to embrace it, and what that looks like?
So to me, it's fairly simple. This is a technology that's here to stay. We're only seeing the beginning of it. It's not going away. And it would be a gross error, in my opinion, to try to ignore it and pretend like it is going to go away, because it's not. And it's going to be pervasive in so many ways, not just in the practice of law, but in the way people live. By the way, non-legal consultants are using this at a much higher rate already. Mm-hmm. Lawyers, we're different. We have these ethical rules, and we're fiduciaries, so we can't get away with just like running with the ball and scoring however we think we want to score. But you have to embrace it, and it's always better to take control to the extent you can whenever you're facing something new, and there's a lot of uncertainty around it. you want to try to control the uncertainty as much as possible. And that means you need to understand it. So you really have to be aware of what's being done. Just as John was saying, you got to start getting granular. What is this tool actually doing? You need to have some understanding of that. And of course, you need to know, what all the traditional risks are, and then what are the new risks and the new types of liabilities. I mean, there's going to be liabilities out there that, we're not learning about in law school today that will be, sanctions, for people or, damages, that may be built upon traditional principles, but they're things that we're not thinking about today. So I think you gotta do it. And just quickly here, one of the things I did preparing for this, so I asked ChatGPT whether law firms should be allowed to use generative AI for legal work. Just very general. Actually gave a pretty good answer. It said, the answer depends on factors such as, it's like a lawyer wrote this, the nature of the legal work, the jurisdiction's regulations, the specific AI technology used, and how well it complements human lawyers. Striking the right balance between automation and human expertise is a key consideration. Legal and regulatory bodies are continuously evaluating these issues as AI technology advances, and they are developing guidelines to govern its use, including in the legal profession. And then it listed a bunch of pros and cons that I won't go over here, but ChatGPT did a pretty good job. It was very succinct. It was, I think it made the right point.
Well, and it's interesting because I was thinking about it as you were talking earlier about the different frameworks and different company or countries and what they're requiring and sort of how they're looking at it. And to some degree, that's something we're already juggling with, with data privacy and other things. The EU led the way on that, and then the United States, California jumped in. And as we all know, in every way, California is different. And so, but things like the right to be forgotten. What does that mean when you're a lawyer and you're required to preserve files for 7 years, or however long your law firm standard is, but if it's financial records, it's 7 years in the state of Colorado. But what does that mean for you to mount a defense? If you get a case filed with the Office of Attorney Regulation Counsel, which has a 5-year statute of limitations, if someone invokes the right to be forgotten and you have to purge your files of all information related to that person, how do you mount a defense if something comes up later? Are you complying with the rules with regard to retention of records if you have to, things like that? And that's probably a bit of a stretch in terms of this conversation, except that it again reminds us that these shifting frameworks aren't new. We're already having to keep track of them. It's just a matter of how do we keep track of them when they're moving at a lightning pace, And it makes me laugh because John used the word entrepreneurial. And I think all of us in this room can agree that as lawyers, entrepreneurial, we really aren't, right? Like, we like to pride ourselves on it, but we are risk averse. And when the law firm I was with was doing a remodel, our brokers were trying to convince us to be like really edgy and cutting edge. And they were like, you guys you're really entrepreneurial. And I said, okay, let's not fool ourselves here. We use lightwood instead of darkwood, but that's about as cutting edge as law firms get. So it's really just this changing of a mindset in terms of, for lawyers, because we tend to be like, new stuff is scary. What does that mean for us? And especially now we get into the conversation John's gonna hate, but Sonny, as general counsel, one of the things that your board is coming to you and saying is, why are these lawyers charging us so much? We need to control our costs. Why don't you have better control over them? So as general counsel, when it comes to those types of things, when it comes to greater efficiency, use of tools, I mean, some corporate clients are already saying you have to use our data platform for sorting our electronic evidence. You can't use yours because ours is more cost effective. Where does that interplay come into this conversation? And could you see yourself as general counsel having a conversation with outside counsel and saying, hey, I want you to use this as this gentleman did in the back. Like, this is a more efficient tool for drafting lease amendments. I don't want you having associates spending time drafting lease amendments anymore. I want you to have AI draft those and save me money. What do you think about that?
So, as a general counsel, I did not like to direct law firms with too much specificity on how to accomplish the work that they're being hired to do, because I wanted to have, the creativity and the independence. But at the same time, I wasn't just letting them run amok either. So there was a balance in there. And yes, you're right, in an in-house setting, one of the things you get pounded on all the time by the business is the cost. And there's been some studies, I haven't seen a more recent version, but a while back, they were plotting on a graph 2 lines. One line was the average amount of money that corporations were spending on legal services over time. And it was going up like this. And then they plotted another line using a different scale, is what is the profitability of, and this was done with US companies, of these companies that were procuring those services. And then you project those lines out, and there would come a point in the future where if the trends continued, the cost of the legal services would be more than the profitability of the companies on average. And so, like, when you go in-house, it gets drilled into you. Like, okay, you can't let that happen. It will never happen. In fact, they tell you, we will cut you off before that happens. And so, your job then is to, figure out the right balance, be within, a reasonable cost structure. You get things that come up that end up costing, 10, 100 times more than you're initially thinking. And those are the really tough ones, because now you're wondering, okay, am I going to cut this off, or do we really need to keep going? And that's where the skill, working in-house is at its highest premium, is being able to have that sixth sense of, is this an issue that's going to kill us? Because if it is, and that's a real probability, then we're going to have to go off budget. And so that comes down to risk management, which is a big part of how you do everything. And so one of the roles that I had in the company, it was a non-legal role, was being the chief risk officer. And so I ran the enterprise risk management program for the company on a global basis. And so when I got that role, I already knew a lot about how to do it, but I wasn't well trained in sort of the academic science of risk management. So I hired a person who was a non-lawyer, and we built the program. And basically, the elements, are fairly logical and simple. The application of them is much more difficult. But basically, the steps are, first thing you got to do is you have to identify the risks. So risk identification. And that starts with identifying known risks that are facing the company. And to do that right, you have to go out into the company and you have to poll everybody and say, what risks do you have, in your department? And then as a corporate organization, you got to pull all that together, because there's a lot of duplicity in that. And then now you have to quantify those risks. And so that's another exercise. And typically the way that's done is you assign a numeric value to the likelihood that that risk is going to occur. And then another number, if it does occur, what's going to be the impact to my company? And that gets typically plotted on what's called a heat map, which will quickly show you which risks have the greatest probability of happening and the highest probability of hurting the company in a very serious way. So then that creates the crucible in which you narrow the risk identification field, because when you do that, you're getting hundreds and hundreds of risks, and you can't deal, you can't manage every single one, to the nth degree. So you pick the top ones, and those you have to now match to what's called typically risk appetite of the company. So that's a whole nother exercise, and that's one where you have to get the board involved and say, okay, what is our appetite for risk A or risk B or risk C? And those are highly variable. Normally, and the way we did it was we used a numeric scale that actually mirrored the heat map so that we could create a target. So if we had a risk was plotted, high on the heat map, we would then we would say, what's our risk appetite for that? And we would get that numeric value, and we would plot that on the same heat map. And usually the risk will be higher up than the target. And then we would say, okay, the owner of that risk is going to be someone in the company, usually a business person. Your job now is to come up with a mitigation plan that's going to move the position, the inherent position of that risk, from where it is to the acceptable place that we want to get. Sometimes that's like nearly impossible, but a lot of times it actually is if you apply good thinking to it and a lot of discipline. So then you have these risk mitigation plans, and then those all have to be tracked, and you have regular monitoring and reporting, and you create a closed loop system so that risks, if it's not moving the position to where you want it to be, there better be an explanation for it, in your reports. And then you have to do that same exercise on a periodic basis because new risks are coming up. And then one of the things we grafted onto that program was an emerging risk platform, if you will, where we would get more innovative thinkers in the company, people who were not at the executive level, they would be more in the middle management, and we would put them in an off-site chamber, and they would be brainstorming on emerging risks that are not typically well-defined, not quantifiable today, but they're out there on the horizon, and if they were to happen, they could be very problematic for us. And one of the first workshops we did, this is 4 or 5 years ago, was on AI. And basically the whole idea was in the emerging risk program was to, as best you can, identify the early warning signals. So if this emerging risk that's way out there starts to materialize and become more of a real risk, what would that look like? And so then you would be on the lookout for those events. And if they started to pile up, then that emerging risk all of a sudden gets pulled into the regular management program. So that's how I approach things like that. And then the other thing I would add to it is, and I would, by the way, I involved outside counsel in the enterprise risk management program, even though it cost me more money to do that, because I valued at a very high amount the insights, because I couldn't see everything they could see. And the business people tend to, have tunnel vision on a lot of things as well. They think, their business is impenetrable and, it's going to last forever and no, they're never going to be disrupted or displaced. So you have to have people who have a contrarian view of things. And lawyers are, pretty good at that. So I would bring, particularly like these emerging risk sessions, I would have outside counsel there. And they loved it because that was actually, so, even this wasn't a discussion about cost. This was like, hey, help us think about the future. And anyway, where I was leading with that is with this use of AI, as I mentioned before, I think companies need to have policies on this that employees have to follow. And you could ask ChatGPT, as you said, they'd probably come up with a pretty good initial draft of a policy for you. But a good place to start most companies are going to have some type of a social media use policy. They're also going to have lots of policies around confidential proprietary information, how to define it, how to label it, how to handle it. So you start with those policies, and then you build from there to create a series of guidelines or rules for employees, and eventually defining approved and prohibited uses. And we're going to talk about some of the prohibited uses, which would be more in the social engineering type categories. But I'll stop there. That's the way I would be approaching this, using disciplined methodology on risk management.
And so, John, as a lawyer who represents companies, insurance companies, other corporations, when you hear that, how would you then think about any cost pressures around, hey, I want you to do every first draft of an amendment using AI so you're not billing me for it? Would you push back? Would you agree? Would you not do it, but then still not bill for it? How would you approach that?
I'd want to push back.
Yeah.
Right, because I don't like that. I mean, you can tell already, right? The other things I've said about not like being told that I can't bill for legal research, or telling me that I can't do legal research when I think I need to do it, and therefore if I choose to do it because I know I have to do it, that I don't get paid for it, right? But I kind of want to go to the example that Sonny raised about the think tank setting people out. I love that because it got me thinking about something about generative AI that I'm really excited about. And it takes it back to watching the original Star Trek series. Remember this? They would ask the computer questions like this, but they would say, "Computer, what does this data mean?" Or analyze what this thing out there is. What is it? And the computer's like, "Oh, well, that is a product of a unknown civilization," or whatever. But the point being that there was some really cool thinking going on there. And as you said, is that what the next generation is going to be doing? So I was thinking in my head, thinking, okay, for anybody here have to use task codes when you enter timekeeping for insurance companies? I don't like doing that either, but some of them absolutely require it. And if we want to represent are insured, we have to do it. Well, guess what? What are those task codes? If anybody doesn't know what I'm talking about, meeting, document, correspondence drafting or review, they get really granular sometimes. But you know what's not there? There could be 50 task codes, and what isn't in the list is thinking. There isn't a task code for thinking. Are we still doing enough of that in the practice of law? I tell my students, I said, when we do a timekeeping exercise and I make them keep time, and I got the idea from Professor K, so I can't take credit for it, but I make them keep time of preparing for class at 6-minute intervals for several days because I want them to think about it. And some people put down travel time and some people don't. Some people put down moot court stuff and some people don't. Some people put down going to a lunch meeting study group. Some people don't. It's fascinating to see just law students before they get into the machine of law and how they would approach these things, right? But sometimes people bill on these for writing out their class notes and outlining, i.e. thinking, and some don't. And I tell them, I say, sometimes in an average day, I have 12 matters I've billed to. And then I look back at that and I say, what was the quality of any of that work? You know what I'm saying? I mean, what was the deep dive anywhere? And I increasingly feel as I practice that we're not thinking enough. And so I like the idea of a tool that might help us do that. I get really excited about that. I also get really excited about just the cut and paste, that kind of what we all might say is more of this kind of work, right? Because there's plenty of that. Some days we have all this, and some days we have none of it. And some days I'm like, please, I need some of this because I burned out, my brain is tired, right? But I think that in terms of the access to justice problem that we have in our profession, which is unbelievable, right? It's the clients, Sonny, that we represent who get and hoard all of the legal resources of our country statistically. And so, when LegalZoom came out, how many people were like, oh man, that's going to hurt me? I mean, we probably weren't saying that, right? But there are a lot of general practitioners out there that were concerned about that. And so at some point, people are going to be able to go online, and the LegalZoom is going to be even better because of generative AI. It probably already is. And I think that's positive in a lot of ways, right? But what's the profession going to do about that to make sure that, the quality of that is good? I mean, so I guess what I'm kind of excited, but also lamenting this, I think we've lost something in law about that, the relationship, the professional advice and candor and advising that's part of the relationship. And I worry that tools like this are just creating more barriers between me and the client. So I don't really have a great answer there, but a lot of ground to cover.
I like it though, and I think, one of the things that we've covered today is not putting our blinders on, not sticking our head in the sand, not refusing to use technologies. And as part of that, maybe it's thinking about those technologies in different ways, right? Like not hand-wringing over, is this going to replace all the associates, or is corporate counsel going to use it to impose new requirements on me, which I heard plenty of law firm lawyers have real concerns about, but instead say, how is this another tool that we can collaborate over? And how is it another tool that can give us just one more way to mutually achieve what we want to achieve? I think that's an interesting perspective on it. And to get to that, I do want to jump ahead. We prepared obviously some materials, but I want to leave a little time for questions. Georgette, we end right at 6, right? Right. Okay, so we'll maybe see if there's any questions about 10 till, and if not, we'll just go into more of the content that we have, because luckily we over-prepared rather than under-prepared, so we're not just going to sit here and stare at each other for 20 minutes. So I want to leap ahead a question and say, I referenced when we started this conversation, the great seminar that Silicon Flatirons did a couple of weeks ago. And one of the things they really talked about, that I've heard talked about a lot, is the use of AI as a tool to help serve the unmet need for legal service in the United States. And this has been a topic that we as lawyers have been fretting about, for as long as any of us in this room probably have been practicing. And, I worked for the Office of Attorney Regulation Counsel for several years. And I remember when I wasn't there when the advertising rules came out, but by the time I joined the office, there was still, hand-wringing and fretting about the fact that we're letting lawyers advertise, and this is just this horrible thing, and we shouldn't be doing this. And as lawyers, we really like to fret, and we really like to fret about change. And there's some good to that, and there's some bad to that. And we keep worrying. I've heard a lot of conversation, and the three of us talked about it too, about, well, by using these AI tools, is this lawyering, right? Are we like LegalZoom, right? Because there was a lot of hand-wringing about LegalZoom when it came out, that it was the unauthorized practice of law, and it was lawyering, and it was going to take lawyers' jobs. Because let's be real, to some degree, we worry because we worry about the integrity of our profession. And I, as an ethics geek, applaud that sentiment. But we also worry from a protectionist standpoint. And a lot of times when I was at the Office of Attorney Regulation Counsel in particular, I would talk to lawyers who would be complaining about unauthorized practice of law. I mean, I'll just say I had lawyers who complained about the clinics at law schools, right? That this is the unauthorized practice of law. And I would say, tell me what your worry is, right? They're practicing law without a license. And it's like, yeah, but they're helping people that no one else is helping, And I'm talking to these lawyers with, $100 haircuts and cufflinks on their French cuffs. And I'm like, these are not your clients, okay? Let's just put that aside. They're not stealing work from you because these people aren't coming to you. So if these clients don't go to clinics, these clients don't have anybody. And so let's start there. And so one of the things that I've heard in this conversation around AI is, we know we cannot meet the need for legal service in this country by donating pro bono hours. It's just not going to work. IELTS, which I'm completely obsessed with at the law firm across, or law school across town, talks about like lawyers would have to donate some insane, every single licensed lawyer in the United States would have to donate like some insane amount of hours every year, like 100 plus, to even begin to scratch the surface of the unmet legal need in this country. That's never going to happen. So we need to be creative in looking for tools to do that. And one of the things that the Silicon Flatirons event really talked about is AI one of those tools? Can we come up with ways to harness this powerful resource to help meet what is currently an unmet need in this country? And so this is venturing a little afield of our expertise, and we don't have perfect answers, but I wanted to give Sonny and John both a chance to weigh in on that because I think that's so critically important for all of us and for the future of our profession. Do you want to lead, Sonny?
Sure. So I think this generative AI can absolutely help solve the access to justice gap. And where I'm coming from, at least in part, is in my experience as a general counsel, for a big company, one of the things that I realized a number of years into it was that in order for the law department to perform better, we needed to train the business clients on how to be better clients. And because, they go off on these tangents and they come in with the most bizarre questions and they're wasting a lot of your time. And then they're complaining about the amount of, the cost and so forth. So it occurred to me, we really need to train them on how to ask better questions. Let's just start with that, which means we had to take them through some Law 101 type training. And we focused that initially, at the top, and then we kind of moved it down, and we had versions of it that were for all employees. And it actually, in my opinion, helped. The clients would, for one, they got a better understanding of what's happening in the law department. But, they were just more intelligent about the way that they would approach how I got a legal problem, I need help with it. So I see in this access to justice as a parallel where these tools, assuming you can get them to the people who need them, that's another issue, that they can use them to solicit a lot of general information that would, about law and so forth. And it's a lot easier for them to do it that way. They're not going to go to a library or, they're going to, it's harder for them to, not going to go on Westlaw, for example. But, just in my own experience with ChatGPT, it'll summarize, some complex concepts in simple terms that are mostly valid. And so I see that as a leap that would help, where people could, just be able to ask better questions when they do. And also, like if they're not going to be represented, but they're in front of, say, a government authority, just having that little bit of extra knowledge that they have experienced, by using these kinds of tools is going to help them represent themselves and get a better outcome.
Well, and one of the things, I think we've all experienced this, right? When you become a lawyer, everyone in your life who isn't a lawyer thinks that you know all the things. And so it's like, they come to you with these obscure, weird questions, and you're like, I mean, I don't know, I do ethics, And so I actually have used it because I had a relative that had this weird question about jurisdictional requirements for marriage or something. And I was like, I mean, your guess is as good as mine, guy. But I typed it into ChatGPT, which in things like this is better than Google because Google's going to give you a list of places to go to find answers, but ChatGPT is going to summarize those answers. Now, again, if you're not foolish, you're going to check that. But I was like, what are the jurisdictional requirements for marriage and blah, blah, blah. And it gave me a good summary because, yeah, I'm not an expert on that either. So, John, what are your thoughts?
Well, Yeah, I mean, I'm going to echo a little bit of what Sonny said. I mean, I agree with all of it, but I think that there's some exciting potential here, and it's pretty hard. And I'll echo too what you said. It's like we can't get upset about it just because we're not, as a profession, meeting this need. So, you know, I do think part of the problem we created ourselves when we shifted to hourly fees. From classic retainer or flat fee type situations, and we created a very significant. I mean, the access to justice issue. I guess what I'm trying to say is it's not just numbers in terms of staff, right? There's plenty of lawyers in the United States, but it's the cost. And as you said, I mean, even companies now are getting priced out. Some of the, you know, I probably got more work from LegalZoom because of a couple of small starting out fledgling businesses that I worked with that got some free stuff, you know, online, and then these commercial contracts or employee contracts went south because they were not very good, right? And then they wanted me to write a better one for them. And so, you know, these tools I think that have been out there are helpful. And if you can just, my question is, how can the profession help, right? What can we do? How can we leverage the power of lawyers, right? We're supposed to be a profession that makes this country and our world a better place and fights for the oppressed and the underserved. And so how do we do that? I mean, can we use our power to lobby and make sure that whatever is out there for free that is getting into the legal field is of some minimal level of quality? I hope so. I think we can. I'm optimistic about that. But, you know, it's going to take a lot of people who are willing to volunteer their time to make that happen.
So we're at 10 till. I want to pause just to see, with the caveat that you do not have 3 tech gurus sitting in front of you. So tailor your questions accordingly. Are there questions out there? Great.
Yes, I actually have 4.
Oh, super.
Oh, yes.
Or actually, I'll give you 3. So the first one I had early on, which was, if you are concerned about ChatGPT and its legal acumen, is the way to limit that to say, okay, you can use generative AI, you can only use a legal database generative AI, so case text or Lexis or whatever version. So something like that makes more sense. My other 2 questions are less specific, and they are not necessarily from your perspective. If one is a judge, has there been consideration about whether, if you file a pleading or brief, you should disclose the fact that you use generative AI in creating that work product? And should judges and/or their law clerks use generative AI in producing opinions?
Do we have a judge in the room? Oh, okay. Hey, well, so what is the judicial branch telling you all in terms of framework?
So I am semi-retired, and so I have not been to judicial conference for a couple of years. So I don't know what they're telling anybody.
Anyone else?
I'm not retired yet, but I get that close. But no, I was just gonna say, in listening, I don't think we're at some crisis, from my perspective at the bench. I think this is just the evolution of what we've been looking at forever. I mean, I was one class behind Sonny. We didn't have word processors. People didn't take the, I think we had 3 people use typewriters. Everybody used blue books and wrote by hand, which I know is shocking. And we didn't have a lot of student loans back then for you poor kids that are there now. But the 2 basic ethic principles that keep running as we went from word processors and then everybody started copying each other's briefs, you know, and then they plug and insert them, is that it has to be your work. And the cases or statute have to be, say what you represent that they do. And I think those 2 ethical foundations apply to AI. I don't have a problem with anybody going to an AI, getting the answer, and then deciding to put it in their own language. Just like when I was in private practice, I'd go to my mentor next door and ask him that question. But I do have a problem with somebody just getting it and inserting it. And the same thing, I have problem with word process briefs. There's a lot of turnovers in DAs and public defenders. They get these handed down to them and they have these paragraphs. They have no idea if they actually say what they did. And so I just see that the evolution, as long as we keep that focus, it has to be your work and the cases or statutes have to say what you say they do. And I'll finish by saying that's really important on the real salient facts. I'll give you a factual situation I had. There wasn't a tape recording of a police officer interviewing a witness. And so defense said, you have to have a recording, I should suppress it. The prosecution said, no, that wasn't. And no one actually looked up about whether their paragraphs said what they wanted them to say in. And so that's when I went back and read the case, and I might have been the only person involved in the case that actually went back and read the cases cited in the motion, and they didn't. And so then I had to come back to counsel and say, counsel, there is a case that's right on point, but neither of you cited. That wasn't a problem with AI. That was a problem with basic ethics of when you hand something into the court, it's your work and the cases or statutes say what they say they do. So I think as we go all through these things, some of it's very complicated and some of it is at a tipping point, but and some of it's fairly simple for us as lawyers to know what our obligations are. Comes up, just like it did when we're processing him and stock motions came in and we had those sorts of things. We've had digests forever that did analysis, West Digest. You know, we didn't think about taking those paragraphs and saying it was our work and inserting it. So I think technology is one thing, but I think ethics is fairly constant on these issues.
Okay, we have another judge here.
I'm a retired magistrate judge, and as such, I worked with a lot of pro ses, particularly in family court, because we all know that 50% of the cases filed involve family court. And folks cannot afford attorneys there. They are already trying to fill in their own paperwork. And, you know, this generative AI stuff could really complicate things for these folks because they don't have a clear understanding 9 times out of 10 about what they're even agreeing to when they come for dissolution of marriage with all of their paperwork filled out and tidy and all of the Sherlocks and all of the, you know, free people that are affording, you know, free advice at the courthouse have filled out. So I think that there's caution and, you know, where does the buck stop? Does it stop with me as the magistrate or my colleagues as magistrates who now have to read every single provision and essentially counsel these parties in front of us about this means this and that means that? Are you sure this is what you're agreeing to? So I think that there's a different level of, you know, the quality and quantity for attorneys and a whole different paradox for the pro ses who are really the ones who need access to justice.
I think that's right. And one of the things that was talked about the other day was not just unleashing internet-based open AI onto the pro se population, but doing it in a more controlled way. Using AI to develop tools that would be developed by lawyers, law schools, clinics, and others with legal standards in mind that pro se litigants could then utilize, whether that's through kiosks at the courthouse or programs that they could access for free online, but that had better guardrails for exactly the reason you're pointing out. You know, and to go back to the question of should it be disclosed, I've heard anecdotally, and you might know if you're going into courts, but I've heard anecdotally that there are judges who are requiring that. Now, back to this gentleman's point, if you're taking what you're learning and putting it in your own words and it's your product, you just use this to inform your brief, I think that's different. But some judges still are saying, this is too new. And if you used it, I want to know that you used it. And I don't think, that's why I wondered what the judicial branch was telling you, because I don't think the judicial branch has come out with clear guidelines yet, but I think some judges are starting to impose those themselves. That's just what I've heard anecdotally.
And I'd like to go back to the very first question, just from the firm perspective. I think you're playing with fire if you're going to say, because eventually Westlaw is going to market and have out a great product. Well, I shouldn't say great. I mean, they're going to have a product out, Lexus is going to have a product out, and everybody's going to make a decision about what they want to use. And there'll be this presumption based on branding and
Yep.
people's long-term experience in using these products, that the presumption is that it's reliable, right? Because we all had to get there with the online stuff as it exists now. But the question is, you tell people, well, you can use this, but you can't use that. That's dangerous. I think you have to, and I like the comments that the gentleman made, because I think that that's the conversation that you have to have with your associates. I mean, if go hire somebody who's fresh out of law school today, they know this technology way better than you do. They've been using it. They've already grown up with this stuff. They've been using Siri and Google Assistant forever. I mean, this is second nature to them. But what you need to make it clear to them is the issue isn't the tool. The issue is what you do with it. And is it, like you said, your work, and this things say what they actually say. I think that's the key. You have to have that nuts and bolts conversation about this is acceptable, this is not acceptable. And you can't just say, oh, I'm sure it'll work itself out. Firms can't do that. I mean, they have to be proactive about this.
I
Just
agree.
to add one quick thing to that, the question that was the first question. So Thomson Reuters is already marketing a new tool they have. It's called Ask Somebody. I can't remember who. Maybe it's Ask John. And what they're saying about it is you can create within their database these chambers where if you ask questions that the content of the question includes confidential proprietary information, that the tool will be prevented from any disclosure or any training on it. So they're already down that path, and they're trying to sell this. I don't know if they're selling to law firms. I know they're trying to sell it to companies right now. I don't know how many people are taking them up on it, but so if you're in that industry, that's actually the outcome you're trying to achieve, because you're going to sell that as a product.
So it's already out there.
Yeah.
And with that, I see small children peering in the window, which tells me that it's time to be thinking about wrapping up. It's 6 o'clock. Thank you to all of you. We had a great time preparing. We had a great time being here, and I thank you for letting us do it. So thank you.